Everyone. Really glad that you are here today. Today we are from the Precepts Group. We are here to talk about business succession, a topic that is actually very relevant to our aging population. My name is Heng. I'm the head of marketing from Precepts Group. I'm the host for today, and together with me, we have a couple of speakers. We have the Mr. Mun Kid. We call him Mun Kid, and Mun Kid himself is our HOD, head of department for trust department, our trust department. And he has been working with trust cases for quite more than 10 years, I suppose, on the various aspects of trust, as well as helping clients to set up the trust and administer the trust, right? And at the same time, another speaker of ours is Miss Esther Fong. Esther Fong is a very established ex-banker. She has been in the banking industry for, I suppose, about 20, 30 years. And she's also handling a lot of high net worth clients or clients with businesses who needs to look at succession planning. And she's very familiar with the Singapore regime as well. And we also have one of our directors, Miss Jaslyn, but she has something to attend to. She will not be speaking, but she may be able to answer some of the questions if it happens on the chat. So if you do have any questions, do feel free to put it in the chat, and the speakers will reply to them, or at the end of the session. So at the end of the session itself, we will have a short Q&A session portion. Now, just to remind you that if you have something that is very personal, that is very just related to yourself, like for example, if you have a South Africa property, and you know that that is a bit too specific to your own family, then do approach our ESP, our estate and succession practitioner, who has invited you to come to our talk, and to actually then they can actually solve your personalized family issues. Right? Okay. So this is how we're going to proceed with the session itself. Now, before we start, we will just like highlight to you that our next talk, some of you have attended my Thursday evening talk, sharing about how do you do charity using as part of your will estate planning. Okay, we'll just highlight to you that our next talk, Monday Estate Planning Talk, is on the 22nd August. This is a talk about the generics of wills and trusts, the basics of wills and trusts. So for those people who are interested, please register with our ESP so that they can register you. Okay, so it's the 22nd of August. We also have a property trust seminar that is coming out on the 15th of August. Yeah, so these two that is coming out in August itself. Okay. Now I'm here to introduce quickly about who is Precepts. Precepts Group itself, my apologies. Yeah, Precepts Group itself is, we are actually primarily a trust company, and we actually have been holding the MAS license for trust. And MAS license details that we actually have to, of course, keep all the each trust accounts separately. And as well as if we decided not to do the business in Singapore anymore, we have to hand over our business to another trust company. So that is the essence. The trust itself, we will help to hold the client's money and distribute according to their intentions. Now, the other part of the business, of course, is which is related, which is the will writing business. And our will writing business, what we do is that we have a legal team that writes the will, and our estate and succession practitioner will be one advising the clients how to structure their estate plan. So they will go through with the clients, okay, Mr. Client, you have this children, you have your grandchildren, and so on and so forth. They were the one who will walk through with you. Then after that, our legal team will be drafting according to the intentions of the testator. We also have a division which is corporate secretary. So for clients who needs to have a company registered, okay, whether it's Singapore, BVI, or so on and so forth, with our Precepts Incorporation department will be able to handle all this. In some cases itself, the trust will hold several companies, and this is how we actually integrate our services together. And for those people who are actually financial advisors who are attending this class, today's sessions, together with your clients, okay, please take note that we do have a lot of classes, training on these specific topics itself, right? And we have also, the government has providing some grants. So we believe that we are actually quite expert in what we do. The truth is we are very specialized field. So we actually conduct a lot of classes for financial advisors, bankers, so on and so forth. Yeah. We have about 2 billion asset under trust, our trustee license, under our trustee license. We already have set up more than 700 living trusts. And we believe that we will continue to have more and more of the clients understand more what is a trust, and they think that, oh, okay, this is something that my family can benefit from. We also have more than 6,000 executorship and trusteeship appointments from the will itself. Clients who have no one to appoint, or maybe just feel that it's better for their family to avoid all the conflicts, they appoint us as executor and trustee for their wills. For the LPA itself, mental incapacity, we have more than 300 LPA Form 2 donee appointment sheet. So we are very much a one-stop shop. And for our wills itself, we have written 12,000 wills. Yeah, that's why that makes us a very, very good specialist. Yeah, because we have all sorts of families with all sorts of needs. And we believe that we need to cater to their needs, because every family is different, right? So we are customized the wills for their benefit. So just to highlight again that for this Zoom ethics, please remember to mute your device, okay? And then we will answer the questions at the end of the whole session. Feel free to post the questions along the way, because otherwise later you will forget the question. Okay, don't worry, just feel free to put the questions in, right? Then after that, just approach our ESP to inquire for further details, right? Okay, yeah. So this one, as usual, I have to put a disclaimer lah. All right, so we're going to start the talk shortly right now, and this is we're going to talk about business succession. So I'll hand over to Mr. Mun Kid, and Mr. Mun Kid himself, he will be able to share a lot of case studies, a few case studies related to this succession plan. Yeah. All right, everyone can see Mun Kid's screen. All right, okay.
Hello.
Okay then.
Good morning. This is gonna be quite different, because business succession planning is not an easy topic, and we did scratch our head in trying to make it as simple as possible. What makes it different is that in a normal estate planning, it can be as simple as just upon my passing, I liquidate all my assets, lock, stock, barrel, change it into cash, give it to my beneficiaries, end of story. Now, business succession planning is totally different, because you may have cases where you yourself, being the founder, the business owner, does not really want to liquidate the business. You want the business to be continued. You want your business empire to be passed on to your heirs, to your descendants, so that the business can continue. So what it involves is a smooth transfer, meaning whatever planning that we are going through, whatever plan that we need to execute, we need to make sure that there's a smooth transfer upon events such as retirement, right? So estate planning may not just, for business succession, it's more than just death, right? It involves retirement, disability, and of course, death itself. So it goes back to the key question where, what is the exit strategy? So just like any other person, when you buy investment property, in this case here, when you're running a business, the key question is always, what is your exit strategy when it comes to your business? Because when I talk to a lot of business owners, their replies could be different, right? I have business owners that come to tell me, well, I don't intend to pass the business to my children. So as far as he's concerned, he would sell the business upon his passing, right? So in those circumstances, what are the planning then? Do we really need to plan for the business, or we just plan for the situation where it is just merely for liquidation upon death, so that in your plan it's just very simple, or it involves a lifetime planning? What is lifetime planning? Because business succession planning involves more than just writing a will and says, I give all my shares or part of my shares to who and who. What you need to plan is, upon your passing, in addition to the shares, is there any key person or any identified successor who can help you to continue your business? All right. So this is what we need to spend most of the time in when it comes to business succession. It's not just about writing a will. We have to spend time with the client, doing a routine review, and ask them, have you identified any person that can help you to manage your business upon your passing? Just a general overview. All right. So because when it comes to business, most often or not, people are very confused on the type of businesses that they have. We have simplified it to just 1 or 2 pages so that we can understand the effects. When it comes to sole proprietorship, right, meaning usually known as sole prop and so on, when the owner passes away, because there's no difference between you and the business, you are the business and the business are you, right? So when it comes to death, the business will be solved by itself, meaning dissolved by itself. It no longer it exists anymore. In a general or limited partnership, similar. So you and your partner may have running a business for the longest time, but if you or your partner passes away, the general rule is that the partnership is dissolved. And the other exceptions is that if it is a limited liability partnership, of course, then there are certain rules dictating that if you have a partnership agreement, who can continue to deal with the interests of your business, what happens to the interests of business in the partnership. And you have companies, private and limited companies. This is a bulk of what we usually look at, where you have shares in the company. And the only difference here is that upon your passing, the company does not die with you. Company is still in existence. And you will need to deal with the shares now in the company. Right? So we are just talking about death. Now, the other part of it is, of course, retirement. As I've said before, there are certain clients where their exit strategy is purely to sell upon their passing. Or, in fact, before they pass away, they intend to sell when they retire. And what's left is just cash. Then when it comes to this kind of situation, the planning could be different. Now, this is from the perspective of the business owner. We are now looking at the perspective of the beneficiaries or the heirs of the business. All right. So looking at the same 4 items here, what we're looking at is upon your passing, as far as sole prop is concerned, because the sole prop has and will be dissolved, what's left for your heirs or your beneficiaries is just the physical items of that business. Most often or not, it's the tools, stocks, monies in the bank account, and so on, and nothing is left. Right? Maybe some goodwill, but that's it. The business may no longer be continued. Same goes to partnership. And for partnership, maybe it's just the monies in the partnership bank account. For a limited liability partnership, usually there's a shareholder or not shareholder part. It's a partnership agreement that dictates what happened to your interest in the business. Would it be sold? Can it be transferred to your beneficiaries? Right? But most often than not, if it is a professional firm like an accounting firm, it has to be sold to the other partners. And of course, the bulk of it of our topic today is about the private limited companies. Can your heirs then take over the shares? And when your heirs take over the shares, that doesn't mean that he gained control over the company. Because if you're not the major shareholder, you're just a minor shareholder, or it's a 50-50% shareholders, then what's going to happen to the shares? Because your family, your beneficiary will just receive the shares and they may not gain any control over the business. Now let's talk about the effect of failure. Right? Failure to plan, in other words. The first type that we most often see is in the case where it is not 100% shareholding, meaning it's between you and your partners and your other shareholders. So the key question here is, if one of the owner or the shareholder passes away or becomes mentally incapacitated towards the extent where you just can't work anymore, right? So what's going to happen? First point here itself, the remaining owner, the business partner, will have to work with the spouse or the heirs of the deceased owner. Because imagine your 50% shares, now that you're no longer around, if you have written a will and you say everything goes to my wife, and let's say your wife will now need to deal with the remaining shareholder than the partners. And on the other hand, the business owner, or rather the remaining or surviving shareholder or partner, now have this issue of trying to deal with the spouse here, okay, who may or may not be able to get along. So there will be a huge disruption because you have now two shareholders who don't understand each other. They're not like you, all right? When you're alive, you're able to talk to your past partners because the two of you are the one who started the business, and things are different if it comes to your children and your spouse, all right? So there will be huge disruption. We talk about effect of failure in a scenario 2, right? There are a lot of scenarios, but we have shortened it to just 3 today. Now, let's say you're the sole shareholder, you're 100% shareholder, right? And upon your passing, what's going to happen is you write in your will, very simple. Everything that I have will be shared amongst my children, for example. Okay, so what you see is the shares are immediately being fragmented from 100%, and let's say you have 4 children, each of them are now inheriting 25% share, right? So meaning the shares are fragmented. And worse still, what if a person passes away without a will, right? Then it will be split amongst 50% to the spouse and 50% to the children, and you can't even designate who will be receiving more shares than the other one. Okay, so if you're thinking that, you know, will business succession planning are more often or not just for the ultra billionaire, ultra high net worth, well, may not be. You see, even a multi-billionaire that we're looking at, Lotte Group in this case here, the founder did not have a will. In other words, he died intestate without ever having a clear and apparent heir of who will be running this conglomerate. So this failure to plan happens to anyone, not just in a small, medium-sized business, but even a huge business like this, right? So this is an important thing to plan. If you look at the facts of going over this case, is that now the founder, shortly before his passing, has actually slipped into dementia. So if you are planning for your estate and your business succession, you better plan it now, because you never know at what stage that you're starting to lose your mental capacity towards the extent where the law or a professional person may deem you to have lost your mental capacity to plan. So in such a case, you can't write your will anymore. Okay, you can't even do any planning. Another example of what happens when the first generation failed to plan, and the problem will actually being brought down to the second and the third generation. Now in this case, this is a court case. That's why we are able to extract a lot of these facts to this presentation. These are all publicly available information, right? It's the case of this founder, Mr. Lim Tiam T here, right? And what happens is he's the founder, and throughout the years, he had actually passed a bit of shares to his son, his eldest son, Lim Beng Kui here, LBQ. There are no other shareholders at that point of time because other children are quite young, they're studying, so they were not involved in the business. So it's just the founder and the eldest son here. And Mr. Lim here is really, really hardworking towards the extent where he worked until 78 years old, and he died while still operating the business. I'm not sure whether he died on the desk. It's not stated in the facts, but he died while still operating the business. Okay, and what happens is that in his distribution, his shares in the business are being distributed into 5 beneficiaries, right? Being fragmented into 5 beneficiaries, including the eldest son here. Subsequently, as you can see, usually the problem doesn't stop there. Rather, the problem starts in the second generation, not during the first generation. Second generation, the second son here, inherited the shares, passes away without a will, And fortunately, through his family members, they are able to come to mutual agreement to make some adjustment to the shares so that there's only one person here being pointed here that would receive the shares and being able to operate or rather come into business. 2015, the main person who controls the business is now no longer around. Okay, Mr. Lim Beng Kui passes away, leaving a will, and to give all his shares to one beneficiary, Mr. Lim Lin here, to hold the shares. Now, all the shares are now being subsequently transferred, legally transferred in year 2016. The second generation shareholders notice about the change of shareholders, meaning there's a transfer of shares. They were not happy. Why? Because as you can imagine, if you're the second generation, you may want to have more control because you're the senior in the family members, right? You want to have your voice being heard. You want to have more control over the business. But what happens here is that the shares are not being transferred to third generation. You were not happy. They actually sued a lot of parties being involved here. You have 2 plaintiffs suing 8 defendants, right? Can you imagine? Over some technicality, that's not a topic that we are going to discuss today because that's a very long topic. They're suing over some legal technicality. Basically, they are saying that the transfer of shares are being illegal. So if it is illegal, means they can't transfer the shares and they are able to buy over the shares, right? Being the remaining shareholders, they are supposed to have this preemption clause that they are able to buy over the shares. Now, ultimately, the case came to a judgment, and the judge basically said that, you know, everything is legal. All the shares transferred are legal. But why do I share this story then? Well, you will see some pattern going on here as we go along. When we share our cases, you'll see some pattern here. The first gen, the problem usually starts from the first gen, all right? First gen failed to plan. Okay, we are not blaming anyone, but just that the first gen failed to plan, leading to fragmentation in second gen. And usually, when it comes to second gen, because in the example just now, we have 5 shareholders now. The second gen will have very limited options. So either they can mutually come to a conclusion that they will buy over each other's shares at a certain point of time. If not, if they failed to plan, meaning there will be further fragmentation as what we have seen just now, then they pass it to the third generation. Now we are lucky in that case. That case is quite lucky because the second gen is just passing to one heir at a time and not to more than 5-10 persons. What if you have 5 children, you pass to all 5 children again? There will be further fragmentation over the shares. And what would happen is that most often than not, the dispute would happen when there's a lesser control over the business, meaning you don't have a majority in the business. Okay, everyone is just holding 20-30%. All right. Then, of course, we talk about second and third generation and what kind of issue that may face. Now, this is just one example. There are a lot of other issues that can happen. But what can be feared sometimes, at least from what I have heard from some business owners when it comes to second generation or third generation at some time, is that they have come to a mutual consensus that they don't want outsiders to come to the business. So most often than not, they look for us trying to seek some solutions. But this is one of their fear. Okay, what if I get my spouse involved and my spouse being operating the business, help out in the business, improve the business along the way, and for some reason our relationship just fall out and we are getting a divorce, right? So what may happen is that my share during this entire ugly divorce, there may be a judgment being came out that, okay, so since my ex-spouse has contributed a lot in the business, she may be entitled to a portion of the business because this is now considered as part of the matrimonial assets because she did contribute a lot, right? Then my siblings will have this fear where, wow, I now have to deal with this ex-spouse. Okay, so this is another issue or fear that at least I've identified when I talk to business owners, and this is especially true for the second and third generation where they have inherited a small fraction of the shares, they are involved in the business. whilst things are going smoothly, they also have this fear. Okay, so we'll jump to now what we call as solution, but we keep talking about problem, but we're moving on to a short discussion is solution. So essentially, in a very simplified manner, business or partners or partnership that is open or being operated with a non-immediate family member. Non-immediate means not your spouse, not your children, right? Meaning this includes your siblings, siblings, friends, all these. If you are operating the business with these people, most often than not, the exit strategy will be using a buy-sell arrangement. Whereas if it is a family-owned business, it could be a closely, tightly held family business among siblings, or it's just 100% shares being held by the founder. Then we're looking at the solution of a trust. Right now, we are moving on to the solution. Firstly, is buy-sell. Okay, so for buy-sell, there are a few things that is being involved. Usually, it's the owners of the business, all right? Otherwise, who will be involving in the business, in the arrangement? And the next stage is that to identify the purchase price, meaning what is the value of your shares. No, the value of your shares may not be the same with the value of your business, right? Or your business may be valued, or rather your net tangible assets may be valued at $1 million, but because you have a lot of contract going on, you have a lot of goodwill, so when you assess the value, your value of your purchase price may be higher than that $1 million, right? Then of course you need to think about what is your triggering events and what is the funding methods. Who would be involved usually? Meaning that when it comes to the certain steps of the planning, these are certain points that we have to think about, as identified earlier. We'll be thinking of who is buying, who is selling, because it may not be a simple cross buy and sell where the shareholders are 50-50. You buy my share, I buy your share. What may happen is that you may have a 70% shareholder and the rest of them are holding less than 30%. So what may happen is that the 70% shareholder may want to buy over the shares of the minority shareholders, right? So we have to think of who is buying, who is selling. Once you have decided on that, you have to think what is the pricing, as we have mentioned earlier, and how do you pay, funding method, and when do you pay. And a buy-sell agreement is a legally binding document that basically binds the shareholders. If anything happens to them, we'll talk about the triggering event later. This is so that to allow the remaining shareholders to be able to continue the business without getting any major interruption. And the outgoing shareholders basically just think that, since let's say I'm holding 20% shares, there's no reason for my family to come in. I would rather being compensated in cash or in monetary form. All right, then I can pass it to my family. The advantages is that, firstly, when the buy-sell agreement is being executed, it guarantees the event of buy and sell. So, for example, if me and my partners, we said that upon passing, I will sell my shares to you and he'll sell his shares to me. So this triggering event is certain. And we'll come to a conclusion of what is our pricing. Okay, what is your 50% shares worth? And as far as the exiting shareholder is concerned, meaning outgoing shareholder person who passes away, he's able to convert his shares, right, into monetary form. This is a very important element because what we have seen before in our administration of certain estates, the issue comes in when a business owner having to focus a lot on the business, okay, focus very less or little to his own cash flow. Upon his passing, the family, what's left to the family is just a huge value of shares, right? It could worth 2 million, 3 million, but the problem is it's shares, it's not liquid. And they still have to go back to the remaining shareholders and trying to bargain out of their way, trying to sell their shares. And it's not going to be a very good bargaining power, all right? And the fourth point here is that the remaining partners or shareholders can have a peace of mind knowing that I don't have to go and negotiate with the families. I don't have to think about how do I get the monies out, right? Because all these things are being pre-planned. What are the possible triggering events? Now, death is the main one. Of course, death is usually the main and sole triggering event, but it may involve other triggering events such as total permanent disability, mental incapacity. What if you get into a divorce? What if you have critical illness, bankrupt? Or what if I'm exiting the business early, right? I'm retiring early. So these things can be inserted inside the buy-sell agreement as a triggering event so that the partner can buy over the shares. Now, if you ask me, in reality, I would focus more on the issue of death and perhaps DPD. Why? Because as long as you're alive, you should have certain bargaining power on, especially when you're retiring early, right? You should have some bargaining power over your other business partners on how much is the value of your shares. So you may not want to fixate everything now and you are unable to come back to a renegotiation later. Okay, so what type of triggering event would then affect how do you plan for the funding? Because insurance can be used to fund the event of death, critical illness, and TPD, but non-insured event, right? Meaning such as your bankruptcy, retirement, right? You can't buy insurance to cover your retirement. You can buy a saving plan, all right, but you can't buy insurance to cover retirement. And you can't buy insurance to cover your divorce. Is there one there? I'm not sure. I don't think there is. So this type of event requires cash funding. So in other words, the most important part of this thing is that once you have determined the value, let's say I know that my share is worth $1 million, the next step is to determine when should I sell it, which is essentially finding a funding method. Why? Because as I have to think on the other side as well, what if I'm not the one who passes away first? What if my partner is the one who passes away first and I need to buy over his shares? How much do I have to pay? If his shares is worth $1 million, does it mean that I have to fork out $1 million in cash to his family? Right? Even if I can come up with an installment plan, $1 million over, let's say, 3 years, we still have about 300,000 per year. How do I come up with that cash, right? So the most effective way in most of our cases is they will buy life insurance policy. It could be term life, universal life, whole life, investment link at certain point of time, certain planning that would just fund over the purchase price. Non-insured event would then require some sort of agreement on how do you pay the cash. Like I said earlier, it can be a lump sum cash payment or it can be an installment. The installment which we recommend usually is not longer than 5 years. Anything longer than 5 years, I think is unreasonable. Okay, just to illustrate how it goes is that in a usual cross purchase or buy sell agreement, you would have two shareholders, and what they'll do is that during their lifetime they'll sign the agreement, the buy sell agreement, and they will buy life insurance policy to cover their own life. And what they'll do is they would assign the policy to each other, meaning I buy my own life, then assign to my partner so that he holds my policy, I hold his policy. And what happens is if he passes away first, right, I'm the policy owner, the money is going to be paid to me. Okay, then I have the cash now, and I have the cash to then talk to the family and say there's a buy-sell agreement. He has agreed for me to buy over with, let's say, $1 million. Here's the $1 million. Please transfer the shares to me now. At the meantime, right? Or I can hold on the cash and say that please transfer now. I must see some transfer of shares form before I give up maybe half of the portion to you, and the rest will be transferred once the shares have been transferred, right? So that what is good about this is that the purchase price has been predetermined. I don't have to renegotiate again. Then the triggering event has been determined. The funding method has been determined. So I have lesser headache over this part. Now, what we do at Precepts is that we take one step further. Now, what you see here is the usual arrangement outside of our company. And what we do is that we take one step further, just like the buy-sell. But in this case here, the insurance policy won't be held by the shareholders, won't be held by that company. or any other person. What we need is a trust deed to be created so that the policies can be assigned to our company to hold as a trustee. And what we'll do is that we'll follow the terms of the buy-sell agreement, and we will only release the monies once the terms of the buy-sell agreement are fulfilled. So think of it as some sort of custodian or escrow where, okay, you have a buy-sell and I have the money, please execute the transfer of shares form, then only I'll transfer the monies out. And what is the plus point about this is because we are neutral, we are not involved in their arrangement, all right? And any sentimental issues, even emotional issues, does not affect us, because as far as we are concerned, we are following the black and white of the arrangement, and you need a neutral party to arrange this, right? That is the plus point about having a trust in this arrangement. Now, so that's for buy-sell. That's when you have an exit strategy of selling your shares to your partners or your other shareholders. But if you're thinking of, well, Mun Kid, I don't want to sell my shares, I want to give it to my family. Well, you're looking now into a second type of solution, right? Where it's just evolved about a will and a trust. And how it works here is that you will set up what we call as a standby trust, right? Or rather, sometimes family trust is a very generic term to be used, but we call this type of trust as a standby trust. I'll give you some characteristics later. So the standby trust, how it works is that it would hold you set up now, and then you must set up together with your will, because these two work together, because standby trust is a dormant trust. What does it mean? You set up the trust, there's nothing inside there except $1,000. Okay? You don't have to inject $1 million, $2 million, even a company shares inside there. It's dormant, it's passive. We don't do anything after setting up the trust. There'll be some minimal admin fee being incurred over time. It's just a 2-figure admin fee, all right? It's not 4-figure, 5-figure. The plus point of it is that because there's no transfer of shares, there's no transfer of assets, you still retain control during your lifetime, right? And you retain the flexibility to change your wishes. For example, today you may be thinking about doing a standby trust. What if 5 years down the road, you think that your business is stable enough, or you want to transfer the shares to the trust now to activate the trust? That can be done as well. So this trust has this flexibility to cater to this kind of situation. But the main point is about this point here, about your will. Because what we want is that a trust that is being held dormant, and it will only be activated upon your passing, so that the shares will then be transferred to the trust. Now, this involves a little bit of planning. So what we do is that you may have other things, such as you assign a policy to the trust so that the trust has cash to provide for your family. The trust can be revocable, irrevocable. I know it's some technical term, but basically the trust can provide certain degree of protection to your assets, right, during your lifetime. And I'll use this as an actual case that we are not administering. So of course, for P&C reason, everything is redacted. I won't tell you anything. But here are some of the key features of this estate. We just call it as estate of S in a very short form. So Mr. S here is the sole shareholder and director of the business. Now this is not a small business. It's quite a medium-sized business. I think the current employee numbers are more than 50. Of course, I put it here as 20, but employees are more than 50. Even during his lifetime, the revenue is in millions in dollars. It's a very well-established brand in his industry. All right, again, I cannot tell you what. Okay, and because of the nature of his business, there's a requirement to hold certain licenses. Okay, so Mr. S, being the sole shareholder, sole director, usually he holds everything, including the licenses. Okay. So what he did is he approaches us. He has identified certain issue, or rather we have helped him to identify certain issue where, because he's the sole shareholder, sole director, and he's the sole signatory, then what happens if he passes away? Immediately, the things that we can identify is check cannot be signed. Imagine you have operating business and your check cannot be signed. Okay. And then tender cannot proceed, meaning whatever contract you're trying to tender cannot proceed because you're gone. So what's going to left is that your employees are going to leave for the competitors, and this will be a losing business for to yourself, meaning you lose your business to competitors. And throughout the process of planning, what we did is that we help him to establish a trust, right? And we are the, just like the standby trust that we have mentioned, and we are the trustee for the trust. And we have also helped him along the way and told him that in your business, since you're the sole shareholder and you're the sole director, there is a need, a fundamental need, that you need to identify a successor. Because as the trustee, we can only help you to administer the shares, meaning we can help you to hold the shares. We cannot help you to operate the business. We don't have your expertise. So you will need to spend a couple of years, or even right now, some energy, effort to identify a successor. He did that, and quickly, not quickly, like he has a plan for his successor, and he managed to identify one. And upon his passing, the ground probate was quickly obtained. What we did is that we take a quick route to obtain the probate, and we are able to immediately change the director to appoint his successor. We use the term professional CEO here because the successor he identified is actually not a family member, and being able to appoint the professional here to be the CEO, and he's now able to run the business without having to face any major interruption, meaning contracts were still being signed, checks are still being signed, business are still running smoothly. All right. So that is what we have done for his case. Now, this is a case where it was done in a, I wouldn't say 100% perfect manner. Nothing is perfect, but towards the minimal requirement where you have set up a trust to avoid fragmentation of shares. You have identified a successor so that when we as a trustee come in, we can quickly help you to appoint the successor to be managing the business. All right. Now, so that's all for my part, because here what I'll do is that I'll be moving to my colleague, Ms. Esther Fong. She'll talk in depth of about another type of solution, which is a private trust company. Don't worry, I know at this juncture you feel like, well, what is it that I'm looking for, right? But she will help you to streamline your thoughts. Okay, she's very good at that, and she will be able to explain what is the usage and advantages of setting up a trust and using a PTC. All right, that's all for my part. Thank you.